I'm Karen Friedman Agnifilo, co-host of LegalAF and MissTrial, two podcasts that talk about the intersection of law and politics. I wanted to talk about this stunning reporting in the New York Times on the United States Supreme Court and Justice John Roberts, the Chief Judge, and how he is taking a huge step forward in helping Donald Trump and has this whole term. I mean, stunning reporting, like Pulitzer Prize kind of winning reporting that is coming out of the New York Times, I have to say, by two reporters, Adam Liptak and Jodi Kantor, who wrote this article about just leaks and dysfunction and things coming out of the United States Supreme Court that, as of someone who's has been a practicing lawyer now 32 years, it is shocking and stunning. I've never seen anything like this. So the leak in and of itself, the leaks, I should say, in and of themselves are stunning. But what it shows is also stunning. Now let's first talk about the leaks. First time I ever saw a leak out of the United States Supreme Court was in the Dobbs decision. Remember when that came out and we got to pretty much see the entire decision before it came out, the one that overturned Roe versus Wade? I don't think that's ever happened in the history of the United States Supreme Court. So that shows dysfunction right there. You would think that they would have tightened things up after that, but this article seems to suggest that not only did they talk to multiple insiders, like this tiny little group of people who work at the Supreme Court. You have the 9 justices, but they also have their law clerks. They each have a handful of law clerks and who work for them and staff, and they all work together, and there's this agreement that everything they do is confidential. Their deliberations are confidential, their memos are confidential, their thought process is confidential. That's to try and allow people to speak freely, think freely, talk about issues freely. It's very hard to interpret the law. It's not like science, right? It's not black and white. It's interpreting the law is an art form as much as it is anything else, which is why it's so complicated and so difficult and so hard, and why two people could see the same thing and interpret it differently. So it's very difficult to do. And the justices of the Supreme Court, who are the ultimate people who make the law and interpret the law, they're a separate but equal branch of government, which means they are as powerful as the president and they're as powerful as Congress, because all three branches are supposed to be separate and equal. And so the United States Supreme Court really has to be able to deliberate freely and speak freely. And sometimes what they do is they convince each other to change their position, or they try to negotiate or compromise, and they try to come to consensus sometimes. But that process, that sausage making, is never, ever in plain view, never something we get to see. But I guess it seems that the people who work there are so utterly frustrated with the dysfunction and with what's going on that they are coming forward, and anonymously, but they are coming forward, and not only are they talking about those internal discussions, they're sharing memos. I mean, these internal memos that we know exist because sometimes we see them, I don't know, years, decades later after after a chief justice dies, and they're released, as part of a historical record. But certainly in real time, no way. And I think it's because, frankly, what's happening is shocking. We've got the United States Supreme Court making new law from just whole cloth. It's like one thing to interpret law. It's another thing to just make it up. That's what Congress is for. Congress makes laws, right? They pass laws. They make them up and create them, and there has to be voting on them. And then the president signs it into law, and then the courts are supposed to interpret it. But here, they made new law in several instances, most importantly in the presidential immunity context. And the reporting in this is just unbelievable. So let's start with what they really talk about in this article is this is all Chief Justice John Roberts. we all thought he was trying to build consensus in the court and make it more legitimate, especially after the leak in Dobbs, but also with all the scandals and controversy involving Clarence Thomas and Sam Alito with the upside down flags, and Clarence Thomas taking vacations from billionaires and not reporting them. These are all things that we thought was absolutely going to roil the Supreme Court, and so everyone assumed Justice Roberts was trying to rein it in and create legitimacy around the court. But this article really kind of suggests otherwise, because when Donald Trump in February was seeking to have the Supreme Court in an emergency appeal, he wanted them to stop that trial that was supposed to happen in front of Judge Chutkan in Washington, D.C. on the immunity case. And so he asked in an emergency appeal for them to take the case and stop it from happening. And what happened was Chief Justice Roberts in February, it's a February 22nd memo, according to the New York Times, sent a memo around, and it was all about whether they should take the case or not. And what he did in this memo is he said he really criticized, they called it a scathing critique of a lower court decision, meaning that Tanya Chutkan, the judge, and the D.C. Circuit, the appellate courts, had ruled that nobody's above the law, that the president is not absolutely immune, and that the case can proceed. And he just gave a scathing critique of this, saying essentially that it was inadequate, poorly reasoned, and he complained that they, quote, failed to grapple with the most difficult questions altogether. And not only did he suggest that the Supreme Court should take the case, but also that how they should decide it. It's like he already knew how they should decide the case. He wrote in this memo, "I think it likely that we will view the separation of powers analysis differently from the appeals court," he wrote. In other words, grant Mr. Trump greater protection from prosecution. Apparently, most of his criticisms were for the appellate court, for the D.C. Circuit. And it's just stunning that he really already kind of thought the president should be above the law, he should be a king, and he should be immune. Now, this reporting goes on to talk about 3 cases that Chief Justice Roberts authored. And one of them was surprising. We didn't know he authored it because it was an unsigned opinion. But now we learned that he did in this unsigned opinion. But they're all related to January 6th. And it's fascinating because you always think that the judges and the law, they're apolitical. They're supposed to be apolitical and not have anything to do with politics. But what's clear about this reporting is they're very aware of how they impact politics. They're aware of the election. They're aware of timing. And they don't care. They absolutely view their role as one that not only can they be involved in politics, that they're going to shape it, that they're going to participate in this. And so it talks about these 3 cases. So number 1, they talked about this unsigned opinion that came out that we reported on multiple times in Colorado, where Colorado was seeking to keep Trump off the ballot because of they basically said he was found to be an insurrectionist. And it was pretty clear that they were going to rule that no, individual states can't keep someone off the ballot, that there has to be a process there. But, different people had different reasons why in the Supreme Court, different justices, but they decided to all come together and say, look, he can't be removed from the ballot. And it was a consensus opinion, and it was unsigned. But we now learned from this reporting that was Justice Roberts. Another one that was interesting that they talked about that we didn't know was the case Fisher versus the United States. Again, another case we've talked about multiple times on both MissTrial and on LegalAF, which is about January 6th and applying a statute. 18 United States Code 1512, which is normally for white-collar crimes. It's obstructing an official proceeding. That was applied to about
I think 250 of the Jan 6 rioters that day, and saying it basically doesn't apply to that conduct necessarily. It has to involve obstructing it with some sort of physical act of like destroying papers or that sort of thing. It has to involve some kind of documents or papers. It can't just be, barging in and trespassing and whatever. So so what was interesting that we learned is that case was originally with Justice Sam Alito, but then all of a sudden there was this flag gate where also the New York Times reported that Justice Alito had upside down flag in front of one house and a Jan 6 kind of a flag that supports Jan 6, or that Jan 6 supporters carried on that day. It's like a green, it looks like a green pine tree on a white background. At his other house. And so it was very clear that where he stands, he's sympathetic to the Jan 6 people. So Justice Roberts took the case from him and he authored the majority opinion, which is stunning, right? But the timing was like within 4 days of the flag being reported on is when he takes it away. That came out in this article. And it was just very interesting because I'm not aware of any other time that somebody in the majority who was writing the opinion suddenly had it taken from them. And, he did write a concurring opinion where he agreed with the majority opinion, but clearly he wanted to still speak his voice and what he had to say. So that was another shock in this of what happened. But the real shocker was the presidential immunity case and how Justice Roberts really froze out the 3 liberal justices and any olive branch that was offered to try and compromise in some way was just ignored, didn't in any way pay attention to them, didn't in any way even acknowledge that there was another viewpoint. And the 6 conservative supermajority just, went crazy and wrote the immunity decision. And Sotomayor was so frustrated that she was frozen out, even though she said, look, maybe there's room for compromise, that she wrote that incredibly scathing dissent that talks about what a monster this decision creates in the presidency and how dangerous it is for democracy. And it's certainly worth reading her dissent. Because of what it talks about. But really, this is huge news coming out of the United States Supreme Court by the New York Times, and some incredible reporting that they've done. I urge everyone to read this article and think about how terrifying this is. They've literally created a monster in their presidential immunity decision. They've made it so that president is immune for all things that he does, or at least presumptively immune for all things he does while he is in office as president, which means it's supposed to be separate but equal. But you get someone like Donald Trump in office and he decides to do things like Project 2025, like going after his political rivals, like doing whatever it is he wants to do that is just lawless. And the Supreme Court's not going to be able to control him. They've essentially made it so that they are powerless to control him. And so that's what's terrifying about this, is even if they wanted to, certainly what they're doing is they're completely enabling him, but even if they wanted to, they can't control him. That's what they've created. So this is incredible reporting. I suggest everyone read it and go out and vote in November. That's the only thing we can do.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the MeidasTouch newsletter at meidastouch.com/newsletter.